Capitol Hill is on edge. A fiery showdown just erupted between Senators Ted Cruz and Mazie Hirono, and trust me, this one's going to echo far beyond the halls of Congress. If you care about the rule of law, political power, and just how far Washington is willing to go, stick around. It all started with a question that cuts to the core of government power. Who holds judges accountable when they cross the line? Senator Ted Cruz kicked things off, and he wasn't pulling any punches. He claimed Congress already nailed down the rules for subpoena notifications back in 2004. It's written in black and white, right there in the U.S. Code. Senators must be notified when their records are subpoenaed. But according to Cruz, Judge James Boasberg decided to toss that law aside at the request of special counsel Jack Smith. Cruz calls it blatant disregard, not just an honest mistake, and he's not mincing words. Nearly 20% of Republican senators had their records subpoenaed, an unprecedented move. Cruz did not hold back. He argued that if a Trump Justice Department had done the same to Democrats, there'd be outrage coast to coast. The tension in the room? You could cut it with a knife. Cruz kept pressing his point, urging Senator Mazie Hirono not to interrupt, but the clash was just heating up. Cruz then blasted comments about Judge Boardman, condemning what he called a massive downward sentencing departure for someone who tried to assassinate a Supreme Court justice. Disgraceful, Cruz said, a dereliction of duty that could fuel political violence. If moments like this matter to you, if you believe real accountability in Washington is critical, hit that subscribe button now. Don't miss a single twist in these high-stakes political battles. But Senator Mazie Hirono wasn't about to let Cruz have the last word. She fired back, arguing the law isn't nearly as clear as Cruz claims. Who's really responsible for identifying whose records are being subpoenaed? Hirono says that's still up for debate, and she shifted the blame, pointing at former President Trump, alleging that calls made by Trump or his inner circle to senators set this whole scrutiny in motion. Cruz shot back instantly. Speaking to the President of the United States isn't a crime, he said, and it never has been. Treating routine conversations between senators and the president as suspicious, Cruz warns that's a dangerous road for democracy. The hearing wrapped up with a new letter from the Administrative Office of the U.S. Courts quietly entered into the record. No objections this time. But, make no mistake, this exchange between Cruz and Hirono is more than political theater. It's a front-row seat to the deep divisions over judicial power, political targeting, and just where congressional oversight should begin and end. With subpoenas, judges, and senators all in the crosshairs, this fight over accountability is only getting more intense. The stakes, nothing less than the future of checks and balances in American government. Stay tuned, because this chapter is far from over.
Great. Thanks, I would note that Professor Vladeck just said if a majority of this committee thinks that senators subject to subpoena should be notified, that they could pass the law. Well, magically, we used a time machine to do that because Congress passed that into law in 2004. It is in the United States Code. It is black-lettered law, and Judge Boasberg disregarded that. Now, he did so at the invitation of Jack Smith, and I would say my Democrat colleague said, well, gosh, it's standard practice not to tell a judge the number you're subpoenaing. It is not standard practice to subpoena 20% of the Republicans in the Senate and the opposing party. And I'm confident my Democrat colleagues would be really pissed if the Trump DOJ subpoenaed 20% of the Democrats in the Senate and concluded with no basis in fact that the mere fact that they are Democrats demonstrates that they, Senator Hirono can respond, but you can, I'm happy to recognize you to respond, but I would ask you not to interrupt me because I am not interrupting you. I am certain my Democrat colleagues would be unhappy if the Trump DOJ, I'm asking you not to interrupt me, Senator Hirono. I did not interrupt you. I am speaking now, and I will recognize you to respond when I conclude in speaking. I am confident my Democrat colleagues would be deeply unhappy if the Trump DOJ subpoenaed 20% of the Democrats in the Senate and concluded the mere fact that they're Democrats means they are likely to be criminals. And I do want to note also, my prediction that no senator would mention Judge Boardman's name proved wrong with the penultimate Democrat speaker. Senator Hirono did mention her name, and 100% of what she said is the decision is on appeal. And I would welcome any of my Democrat colleagues to say that Judge Boardman's decision to deviate downwards by 22 years to reward an assassin, an attempted assassin, the Supreme Court justice, is anything but disgraceful, brazen, and encouraging more political assassinations. To defend it is anything other than a complete dereliction and abuse of her oath of office. Senator Hirono, you're welcome to respond.
You know, you talk about using facts. Well, the law that we refer to is not exactly clear on who bears the responsibility for asking who the heck's records are being subpoenaed. And by the way, if you want to blame somebody for the fact that 20% of Republican senators' records were subpoenaed, you can blame President Trump because he's the one who was calling all of you, or he had his minions calling all of you. So there you go. That's all I have to say.
You know, it is an amazing statement that Democrats now believe that the fact that a member of the Senate speaks to the President of the United States is sufficient to subpoena their phone records and presume they are criminals.
Why don't we move
because,
on?
Senator, you don't get to say move on because you don't have the gavel, but I will say this. Sad to say, well, perhaps if you hadn't presided over a disastrous economy and an open border and wars across the globe, you might still have the majority, but you don't. And my point is very simple. It is not a criminal conduct to speak with the President of the United States, and it is ludicrous to suggest that it is.
And of course, I didn't make that suggestion, so that's why I'm saying, can we move on with this?
And while we're doing that,
Unnecessary
since
hearing.
Professor Vladeck mentioned a letter from Director Conrad at the Administrative Office of the United States Courts, I'd offer that letter that he mentioned as an additional exhibit.
The letter will be admitted without objection.